be a situation that bonus is, the employee is entitled to bonus, but the employer is not giving the bonus at all. It could be a situation that there has been death of employee, so the legal representative is entitled to get the bonus of the person, right? Because it's a statutory bonus. And there could be a situation where bonus is given, but it's not paid adequately, right? So here the employees are entitled, this is under section 21 of the act, that you can make an application to the appropriate government, which is the state government mostly for you all, and you can state the amounts, and then the government will issue a certificate to the collector to which the amount should be recovered. Okay, this is how the process would happen. However, there have been a lot of judgments by the high courts, by the Supreme Courts, and it has been said that where any dispute, like industrial disputes happen, even in this manner, if there is a dispute related to payment of bonus, it can be categorized as industrial dispute within the meaning of the Industrial Disputes Act. Okay, and I'll just open the Industrial Disputes Act. I'll take you through the schedules actually. Just a second. Yeah. So Industrial Disputes Act, there are two competent tribunals. It's either the Labor Court or the Industrial Tribunal. Okay, we will learn the act in detail later on. But the only thing that I want to tell you that, see, these are the schedules to the Industrial Dispute Act. It is clearly telling you that what are the matters within the jurisdiction of Labor Court and what are the matters within the jurisdiction of Industrial Tribunal. Okay, so matters related to bonus directly go to Industrial Tribunal. Okay, so if this is coming in as an industrial dispute, you can directly approach the Industrial Tribunal as well, and this is classified as an industrial dispute as per this act. So there is provision under the ID Act that Industrial Tribunal may very well, under the third schedule, this is section 7A, entertain any dispute arising out of non-payment of bonus or less payment of bonus to the employees. Okay, so you can approach the Industrial Tribunal for filing a claim. Okay, what happens is there have been cases. Okay, so the process of filing an application for claiming is Supreme Court has said, this is a 1995 case, that application under the Industrial Dispute Act for claiming minimum bonus is very well valid. Okay, and there is another judgment where a person or where the group of employees had filed for a claim before the Labor Court. Okay, so this happened in the year 2008. The case name is Himachal Pradesh State Electricity Board versus Ranjit Singh. Okay, and the Supreme Court had dealt with this, and it said that the Labor Court has clearly been excluded. We just saw Schedule 2 and Schedule 3, right? So it is only the Industrial Tribunal which has been conferred with jurisdiction to hear matters related to bonuses, and therefore anything coming through the Labor Court is not going to be taken up. If you have to claim, you have to go before the Industrial Tribunal. So if there is less payment, non-payment, all of those things, which is the court, it's the Industrial Tribunal, and you have to file for proceedings per the Industrial Disputes Act. Okay, now let's say that cases have been filed, right? And you as a company, how are you protected, or how can you defend yourself? So provisions under the act are section 29 and section 36. I'll take you through them right now. I'll share my screen. So these basically tell you that when are you exempted and how can you defend yourself if a proceeding is filed for. Okay, so this is section 29. Okay, offenses by companies. Okay, if a person committing an offense under this act is a company, okay, which is all of our cases mostly, and at the time of offenses was committed, was in charge and was responsible, the company for conduct of business of the company as well as the company shall be deemed to be guilty of the offense. मतलब जो भी इंसान responsible था, in charge था, conduct of business कर रहा था, that person is going to be liable and proceeded against. Company के against offense आया तो company is a legal person. There is going to be someone who is in charge, who is taking care of the business. So it is that person who is going to be proceeded against, number one. However, nothing in this subsection shall render any person liable to any punishment if, this is our defense right here, you prove that the offense was committed without your knowledge, or that you had exercised all due diligence to prevent the commission of such offense. So let's say that there is a miscalculation and you have, as in the capacity of a managerial staff or an administrative staff, exercise due diligence. However, it is not your fault. It is the person, or there is a mistake in accounting, or you have, many times it happens that there is misappropriation of fund. But if you can show that there is due diligence on part of the company and this was not their fault at all, you may be excused. So that's your excuse and defense, that you need to show that it is happening either without your knowledge, or if it is happening, you have exercised due diligence and you have tried everything that you could do to prevent such commission. Okay. Notwithstanding anything contained under subsection 1, where offence under the act has been committed by the company and it is proved that the offence has been committed with the consent or the connivance of, or it is attributable to somebody's neglect. Okay, this could be a director, a manager, a secretary, or the officer. Such director or any other person shall also be deemed to be guilty and punished accordingly. So it is not only the person who is in charge. If it is with the consent of another director manager, if it is in the connivance with another director manager, even they could be proceeded against and punished accordingly. Okay. And your second defense, so first is that you have to show that या तो हमें पता नहीं था या हमें पता होते हुए भी we have taken all the efforts to prevent this. Okay. Power of exemption, आप बोल सकते हो कि if appropriate government having regard to the financial position and other relevant circumstances of the establishment is of the opinion that it will not be in the public interest to apply all or any of the provisions of this act, it may by notification exempt such period. So organizations का financial status देखते हुए you can get exemptions from your appropriate government. The appropriate government may pass notification and exempt you from the provisions of payment of bonus. Looking at the probably NCLT proceedings are filed, probably insolvency resolution is now there, and you're going into huge losses. You don't even have money to pay to your creditors, or operational चीजें carry out करने के लिए भी पैसे नहीं है. So appropriate government may exempt the category to not pay payment of bonus. So this is either you could be exempted from payment, or you have to show that you have exercised due care and diligence, however the act has been happened. So these are the defenses that are available to you if you are on the side of an organization, which all of us would be ideally.